Hello everybody, good evening. Welcome to JAIIB CAIIB English Medium channel. I hope that all of you are doing fine. And today in this particular video, we will be talking about the principles and practices of banking under the series which we are covering, namely the Hero to Superhero series. In this particular series, the agenda is very clear. We are talking about the concepts. Along with that, some quality MCQs will also be discussed. So when I talk about PPB itself, the subject is not that easy. Why I am saying this? Because mostly the questions which are asked are data oriented. Fine. Now you will think that how the data is asked in the PPB. More or less the rules and regulations, they have certain data points, certain numerical values are there, number of years might be there, certain percentages will be there, then there will be certain questions or certain topics where we will have to remember the adjudicating authority as well. So all these things, if you are to learn or for that matter retain for all those 55 units which are there in PPB, you must revise properly. And after the session is over, be it the Hero to Superhero series or for that matter the PYQ session which we conduct, you must revise. And now since the time is less, effectively we have only 2 months for our preparation. The remaining time period will be there for the revision only. So you must pull up your socks, because after you are done with the syllabus, revision is to be done, mock test practice is to be done. Fine. So now let's move on to our class, that is the class 7th of PPB. And in the last class of your Hero to Superhero series for PPB here in this channel, we have seen that what are the types of accounts, various types of accounts we have discussed, right? But today we will be extending our discussion for further more accounts, because students often get confused when we talk about the various types of accounts. So starting our discussion with the accounts, that is HUF, the Hindu Undivided Family. What all documents are required and whether these documents are sufficient to open an account or not. What all criteria are involved while operating the HUF. Let's see one by one. So these characteristics are very important. IIBF asks the characteristics time and again. So starting our discussion with the HUF, that in HUF the business is inheritable. Such points have been asked earlier in the exam as well. So you always remember that HUF business is inheritable. Once the Karta dies, or for that matter there is demise of the Karta, the whole family will be responsible for the operation of a particular, you can say, account. And who will be the primary account holder? Whosoever inherits from the Karta. Where a Hindu dies leaving a business, it passes on to the legal heir. The members of the family are called co-parceners, and the eldest male child is the manager or the Karta. Fine, manager or Karta, one and the same thing. And when we talk about the Hindu Succession Act, since 2005 amendment to Hindu Succession Act, daughters, whether married or unmarried, they are recognized as co-parceners. Fine, that is very important. Earlier only the male members were deemed to be a co-parcener, but now after the amendment of 2005 we have the females also as the co-parceners. Eldest female member of the family can be its Karta in a HUF only after the amendment has been made. When an account is opened in the name of HUF, all the adult members have to sign, even though the Karta would operate on the account. Fine. So operational rights, or you can say the primary holder, will be the Karta, but signature of every member of the family is mandatory. So these are very small things when you just read from here, but while sitting in the examination you often get confused that whether the signature is required for every member or not, or only the Karta signature will be there while opening the account. These confusions should not be there with you while you are attempting the actual examination, and for that only you need to practice a lot. Documents which are required for opening the form: first of all, account opening form. Then we have the SS, that is specimen signature card, signed by the Karta. Joint Hindu family letter signed by all the adult members. Fine, not the minor or major concept. Fine, minor or major concept, no, we are talking about the adult members. Minors 10 years for our banking system. In case HUF has minor member, the natural guardian will be signing. Okay, plus along with that the KYC should also be accompanied while establishing or opening the account for a HUF. So all these are important documents. Now let's move on to the next type of accounts or the customer, that is your sole proprietorship. In the last class we have seen the public and private limited companies. There were certain rules, regulations there, a limit was there. What is the maximum number of members in the public limited? Can anybody tell me what is the minimum number, like that? Here also we have to learn certain characteristics, certain parameters will be there while discussing the sole proprietorship firm. The law does not distinguish between a proprietor and her proprietary concern. So always remember, whenever we are operating an account which is in the name of a proprietorship firm, then there is no distinction between the firm identity and the particular individual's identity. The accounts of proprietorship firm can be treated as the account of individual. That is the reason why we say that the account of proprietorship will be treated as an individual only. The saving accounts cannot be opened here. Again, one exception is there, and since I have told you earlier also that exceptions are the areas from where IIBF will be asking you the questions. Proprietorship firm does not require any document of incorporation, nor is it required to be registered with any type of statutory authority. So no registration as such is required, like there was mandatory registration certificate to be given by the other type of accounts. But here in the sole proprietorship, no kind of document is required for you can say opening the account pertaining to the registration. So what are the documents for opening the proprietorship firm account? First of all, current account form will be opened because no saving account is there. So how you will operate as a proprietorship concern? You will be operating via a current account. Specimen signature card signed by the proprietor, and the proprietorship declaration or the letter as per the bank's format. Fine. So declaration will be given, but on the format which has been prescribed by the bank itself. So these three documents do remember for your examination. Now let's move on to our discussion for the partnership firm. Proprietorship concern can be treated as an individual fine. Proprietorship firm can be treated as an individual account. But when I talk about the partnership firm, here are two or more individuals which are becoming a partner in the business, and the liability is of concern for us as a banker. So where is this mentioned? The partnership firm, section 4 of Indian Partnership Act 1932 defines a partnership. So these rules, regulations, statutes, laws are very, very important for the PPB, and that is why you must remember the specific sections also. That Indian IPA 1932, but which section? Section 4 defines their partnership. Registration of partnership is optional except in the states of Gujarat and Maharashtra, where the registration is mandatory. Always remember, exceptions are very important for our examination. Questions will come from there only. Rules for opening and operations. So what all rules are there? 4 or 5 important rules are there. I have enlisted them for you so that you can just have a look here. Partner should sign for and on the behalf of the firm. Fine. On the behalf of the firm you are signing, fine, not as an individual but on behalf of your partnership firm. In case of any dispute among the partners, if any partner gives notice of stoppage of operation, all the operation must be stopped. Fine. It's not that a specific operation will be stopped. Check operations pertaining to the check will be stopped only. No, every operation will be stopped if the same has been given by the partner. Then the account would be operative only by all the partners jointly. Fine. All the partners jointly will be operating the account, and the norms for that we have seen in the another chapter for your accounts, where we have seen what, how the joint account will be operated, either or survivor jointly, how they will be doing the signature or for that matter the ultimate operation. When there is an addition to partnership, the old account can be continued if the balance is in credit. If it is in debit, new account will be opened. If the debit balance, the old account should be freezed. Death of partner, dissolve the partnership firm automatically. The operations of the account should be stopped. The banker should close the account of the firm and secure the letter of administration from the court. Fine. So what happens when there is death or demise of a partner? It is highly important. So it will directly dissolve your partnership firm. Okay, the partnership firm will be dissolved, and when we talk about what should be done at the banker's end, the banker should close the account of the firm and secure a letter of administration from the court. Okay, so courts will be involved, and when we talk about how the administration will done, it will be at the discretion of the court itself. Now let's see that how the rules and regulations for the operation of your partnership firm account is there in the book also, as well as defined by the regulatory authority, that is RBI, where two of the partners of a firm executed a promissory note. Fine, always remember, promissory note is what? A type of note wherein you are promising that yes, I will pay you this much amount in favor of a third partner, agreeing to pay him a certain sum due to him. It was held that the remaining partners are not bound. So liability of the partnership is separate from the liability of an individual. If an individual partner has given the particular promissory note to certain individual, then it is the liability of that partner only, not the entire partnership firm. No partner has power to do the following: open a bank account on behalf of the firm in his own name. Fine, the partners cannot do that. Withdraw a legal suit filed by the firm. Then admit any liability in a suit or proceed against the firm. Acquire or transfer immovable property on behalf of the firm. These things are prohibited. You cannot simply open a bank account in the name of the firm and say that yes, I am the sole you can say I am the sole person who will be operating this account, that is why I can open the account in the name of partnership firm. No, such type of things will not happen. You cannot withdraw any kind of legal suit, neither you can file a legal suit against your partnership firm. Plus you cannot acquire or transfer any kind of immovable property on behalf of the firm. So that is why it is said that liability of an individual partner is different from the entire partnership firm. Any partner can countermand the payment of check drawn by another partner, so that can also be done. Retirement of a partner needs stoppage of the bank account operations and new account shall be opened. Right? So the account on retirement of a partner will be what? It will be closed and new account will be opened. So such type of things we have to remember, and questions definitely they can ask from all these topics. Okay. Next is how the partnership firm account will be opened. What all documents you need to furnish if you want to open an account pertaining to your partnership firm. So current account will be opened up. So current account opening form, SS card, that is specimen signature card, partnership letter signed by all the major partners. Fine, one term will be there in the partnership deed which says that major partners are 1, 2, 3, 4, whatever the list is. So the partnership letter must be signed by these major partners. Original partnership deed with a certified copy. So copy will be certified, but along with that original partnership deed must also be accompanied. Certificate of registration, which is optional. Instructions regarding the person's authority to operate the account. And all those persons, all those individuals who are authorized to operate this account, they must be having certain instructions, and those instructions must also be submitted in the bank, so that we know for sure that how the check which has been provided by a particular partner, whether it will be requiring the sign of this partner or some other partner as well. Then we have PAN of the partnership firm, which also needs to be furnished by the banker. Okay, so yes, these are the most important documents. Next we have the trusts. How the examiner asks questions from the trusts. Simply they ask about the documents which are required for opening a trust account. First of all, it will be the current account again. So current account opening form signed by all the trustees. Specimen signature card signed by the authorized signatories. Then we have trust deed. Okay, whether it must be original or a copy will do it, it is at the discretion of the bank. But in the partnership firm, always remember original partnership deed must be there. A copy of the registration certificate, then trust letter and resolution adopted by the trustees should be obtained with regard to operation of the account signed by all the trustees. So this trust letter is very important. when we talk about the accounts of a trust letter defines everything, what all instructions need to be followed by the trustees, and how the banks will be providing the services for this particular trust account. Where no trust deed is available, some document evidencing the existence of the organization to be examined and obtained if satisfactory and with due approval. So mostly the banks rely on the trust deed only. If there is no trust deed for now, banks can accept certain alternate documents, but with a stipulated time period that after 2, 3, 4 months you must submit the original trust deed as well at first place. Permanent account number of the trust or the form number 60. So PAN of the trust, or for that matter form 60, must be given to the banker for opening the account of trust. Next we have the account of some other customers known as executor and administrator. What is this, an executor, and who is an administrator? Executor is the person who executes. Administrator is the person who administers all those activities in a particular entity. Fine. So executor is a person named in the will and derives title immediately after the date of the death of your testator. Fine. Whosoever has given the will, for the purpose of administration of the property of the deceased. So when we talk about this executor of a particular will, or for that matter administrator, these terms are from the European countries' law. There was a law present back in 1700s till 1800s, 1900 also, that if a particular person dies and they have an estate that is big farm, then who will be administering that farm, and whether the administrator can be different from a person who has been nominated by the deceased person in his or her will. He must obtain a probate from the court of law before acting as an executor. Fine. So court of law will be also involved in this type of setup, and mostly the courts give the judgment in the favor of executor until and unless some specific things have to be adjudged. Administrator is a person appointed by the court to manage the property of deceased who had died without leaving any kind of will. Fine. So if there is no will, directly administrator will be appointed by the court. Executor or administrator cannot delegate her power to a third party, that yes, the deceased person has given me the power as an executor, I will be delegating my power to, let's suppose, my brother. No, it cannot happen. So rules of opening the account here. The account of executor and administrator. The account of an executor or administrator should be opened strictly in accordance with the probate. Fine. What is probate? Probate is nothing but a particular mandate which has been set by the deceased person, or the letter of succession, or letter of administration, or administration journal certificate issued by the competent court. Fine. Court will also be issuing certain certificate as per the law prescribed in the will also. The account is to be used only for the funds related to estate of the deceased. The account is opened in the name of the individual with the word executor and administrator suffixed, also with supplementary title with estate notion. Fine. So executor Ajay, administrator Vishal, like that. Okay. So the prefix will be there. The funds in the account are to be disposed in accordance with the probate or the letter of succession. Expenses incurred in the connection with the execution of the order may be debited to the account. Fine. Account will be credited via a particular certificate issued by the competent authority, that is court. Okay. So now let's try to solve a question based on whatever we have studied. Question says, which of the following is a mandatory document for opening a trust's account? Such kind of questions have been already asked in the PPB examination, and chances are there that they will be replicated by IIBF again, because these are important ones. So trust account, what all documents are mandatory? Do we have to submit a current account opening form signed by all the trustees or not? Yes, we have seen that. Personal bank statement of the trustees, not required. Copy of the company's annual report. Why? Letter of recommendation from the local government official. Again, it is not required. So correct answer will be option A. Okay. All of you must tell me the right answer in the comment section, or for that matter the live chat section. Next question says, based on the information which has been provided here, which are the following statement about the partnership firm is correct? So 4 statements are given to you. You have to tell me the correct one. Partnership is defined by section 10 of IPA 1932. This is the reason why I was telling you that specific sections are important for our PPB examination. No matter whether you know this or not, that IPA 1932 is the sole law, sole criteria, defines the sole criteria that how the partnership firm will be established. If you do not know the specific section, you are not in a position to solve this question. Registration of a partnership is mandatory in all the states in India. Then what about the exception which we have seen? Registration of partnership is optional except in the states of Gujarat and Maharashtra. Partnership deed is defined by the Indian Company Act 2013. Why Indian Company Act will be there? Fine. Correct answer is option C. That is, registration is optional, but Gujarat and Maharashtra it is mandatory. Okay. Section 4 of the IPA. And partnership is defined in the IPA 1932 only. Okay, so yes, this was it for today's class. I hope that you have learned something new, and after the session is over, you can directly go to the virtual library, the link of which is given in the description box also, and here you can have the scanner for yourself. You can scan this particular scanner and directly you will be redirected to the virtual library. Okay, there you will find the PDF of this particular lecture. Okay, so all the best for your preparation. We'll meet in the next video.